Hey, everybody, we're back for part two of my series on the Ripple lawsuit court order. If you haven't seen the first video, we went through the first 8 pages or so, going through the facts, and also I give a little bit about how to read a court opinion or a court order, really any court document. So that way it's a little bit easier for you to follow along if you're not a lawyer. And today we're going to be going through the procedural background, which is an explanation of how we got to the order on the motion for summary judgment, and then also the legal standards that the court is going to be using to basically decide the case. Now, I have read a little bit forward, but I have not read the analysis section. I'm going to save that for the next video. But why don't we just go ahead and jump in here? Okay, so we left off on page 8, and here is the procedural background. On December 22, 2020, the SEC commenced this action. And again, you see here ECF number 1. That is the first document that was filed in the case. An amended complaint was filed on February 18th, 2021. Amended complaint. Fact discovery closed on August 31st, 2021. Now, if you have never been involved in a lawsuit, fact discovery is a period of time in a case where the parties are allowed to basically forcibly find out information from the other side about, like, hey, what is it that you are claiming against me? Like, what is it that what are the goods? What do you have? And so that period of time to make those demands and to try and get those documents and whatever other evidence the other side has ended on August 31st, 2021. So a couple of years ago, almost 2 years ago. And that was actually kind of a short period of time, December 2020 to August 2021. So what is that? A little bit more than 8 months. That's not a ton of time for a big groundbreaking case like this. So, oh well. Then we have expert discovery concluded on February 28th, 2022. And expert discovery is kind of the same thing, but as the name would imply, it involves experts. So in litigation, when there's topics that really someone has to have specialized knowledge in order to be able to talk about it, it's going to be expert testimony for the most part. And they produce reports about what they're going to say. And that is something that is also subject to discovery. So there can be depositions, which are formal interviews to find out really what is this expert going to say. So that period concluded February 28th, 2022. That's a good amount of time. So, okay, on March 11th, 2022, the court denied the SEC's motion to strike Ripple's affirmative defense that it lacked notice that its conduct was in violation of law, in contravention of Ripple's due process rights. So, for anybody that's been following the case, you might have remembered sort of Ripple's argument that, hey, we came to you, SEC, and we asked you specifically for some guidance on how to deal with this. And we met with you several times and you did not give us any real guidance on this. And now you're suing us saying that we should have known it was a security all along. Well, I thought that was a really great argument. And I don't know yet if the court really took that into account. But apparently SEC tried to stop Ripple from making that argument and they were unsuccessful. And that was last year. So good news on that front. I do kind of remember that news coming out. That same day, the court also denied Garlinghouse's and Larson's separate motions to dismiss. So what that means is Brad Garlinghouse and Christian Larson, they were both trying to get out of the case in their personal capacities, or at least in whatever capacity they had been sued. So they made what's called a motion to dismiss. And by the way, if you don't know by now, a motion is just a request being made to the court for a court order. So a motion to dismiss is a request for a court order dismissing Garlinghouse and Larson. And the court denied that. So basically that means that Brad and Christian are in the case and they are not getting out of it. So they're in. On March 6, 2023, the court granted in part and denied in part the parties' motions to preclude expert testimony. So, very much like this court order that we're dealing with right now, the court found some things that it liked from uh, one motion and denied other parts of another motion. It basically, she just didn't give everyone everything that they wanted uh, in these motions to preclude expert testimony. And preclude is a fancy word for just prohibit or throw out. So there were apparently some motions to throw out expert testimony that were filed by both sides. So um, some things were agreed, or some things were granted, and some things were not granted. Don't know yet if that really is going to play into this court order. All right, before the court are the parties' cross motions for summary judgment filed on September 13th, 2022. So expert discovery concluded on February 28th, 2022. And then the cross motions for summary judgment were filed later that year in September. So there might have been expert reports that were attached to it. And I haven't been following those motions that were made, so I don't really know. But we'll see if that's involved in the court's opinion. Okay. The court has also reviewed. So the motions were filed in September of last year, and it's almost been a year. So when people tell you court cases are long, that's why. Okay. This is a very important motion that was filed, and it took almost a year. It took 10 months, basically, to decide that. The court has also reviewed amicus briefs from Accredify Inc., DBA Invest Ready. That's DBA stands for Doing Business As. The Blockchain Association, the Chamber of Digital Commerce, Coinbase, Cryptillion Payment Systems, the Crypto Council for Innovation, IvoryMet Inc., the New Sports Economy Institute, Paradigm Operations LP, Philip Goldstein and the Investor Choice Advocates Network, Reaper Financial, Spend the Bits Inc., TapJets Inc., Valhill Capital LLC, VeryDAO LLC, and the famed XRP holders Jordan Deaton, James Lamonte, Maya Lamonte, Tyler Lamonte, Mitchell McKenna, and Christiana Warner. So what is this all saying? Why did I just read these names? They, as you might know, filed what are called amicus briefs, which I haven't really seen those used in a trial court case, but hey, I think this is a big case, so the court probably allowed it. Amicus briefs are basically reports or written documents that are submitted by people who are not a party to the case and who want to just give the court their thoughts, their understandings of how the court should maybe rule in the situation, just to help the court with its decision, maybe giving different perspectives that the parties in the case are not, as of right now, providing. So she had to listen to a ton of these or read a ton of these. And it's a running legal joke that briefs are not usually very brief. So if you wondered why it took 10 months, it's probably because she had to read all this from all of these folks and maybe considered it in her opinion. So we'll see if she thought any of that stuff was persuasive. We got a footnote 10 here. Oh, and a footnote 9 somewhere. There it is. Footnote 9. Accredify Inc. did not formally file an amicus brief after the court granted leave to do so, but included its brief as an attachment to its original request. So what that means is just Accredify jumped the gun a little bit. They just made the request to file an amicus brief, and at the same time, they just attached their brief. So it's just they skipped a step to save some time, is what that sounds like. Footnote 10, on November 4th, 2022, the court directed that any requests to file amicus briefs be filed by November 11th, 2022. William M. Cunningham and Anup Bungay, both pro se litigants. Pro se just means without a lawyer. So that's another fancy legalese there. each separately requested leave to file an amicus brief on November 16th, 2022. So that must have been William Cunningham, 5 days after the deadline. And January 20th, 2023, it must have been Anup, respectively. So that's a couple of months after the deadline. Cunningham's and Bungay's requests are denied as untimely, and that is not surprising. Federal courts are usually very strict on deadlines, and if you're gonna be late and you know it, you got to just ask permission to file late. If you wait till afterwards, you're gonna get denied typically. So, yeah, sorry guys, should have been earlier on that one. All right, discussion. So now we're getting into the legal standard. So this is what framework is the court going to use to decide this motion? Okay, this is it's not as simple as just, hey, you have really good arguments about why this motion should be denied or granted. I need to understand under what circumstances am I allowed to grant it? Am I allowed to deny it? That sort of thing. So I don't get hit with an appeal and get reversed on appeal. So these are the guide rails. This is what the legal standard is about. So this part's going to be a little dry if it hasn't already been dry for you guys. So just strap in, you legal nerds. Here we go. Summary judgment is appropriate where the record shows that there is no genuine dispute as to any material fact and that the moving party is entitled to judgment as a matter of law. So what that means is if we're going to do this thing called summary judgment, which I talked a little bit about in my first video, there has to be no genuine dispute as to any material fact. That's kind of like the first half of this analysis. And material just means important. That's like another fancy legal word for important. And no genuine dispute means whatever it is you're saying is wrong with this important fact has to be like a legitimate dispute. And when they say dispute, it really just means one person says the fact is this way and the other person says the fact is another way. So the typical example that's used is if you're in like a car accident case, someone might say, hey, the light was green when I went through the intersection. And someone else says, no, the light was red. So that's going to be an important fact. What color was the light when the person went through the intersection? That's a genuine dispute as to a material fact. Now, what is an ungenuine dispute to a material fact? That's where someone says something silly like, well, let me give you an example of a case that I just did recently. So there was a contract that had a particular date on it with the people's signatures, and someone had misstated the date, like they just transposed a number or something. So instead of like being September 7th, 2015, it said like September 17th, 2015 or something. So the person opposing the motion said, I dispute that material fact. That was not the date of the agreement. And it's like, okay, it's not a genuine dispute because the contract says what it says. Just because someone wrote down a different or had an error doesn't mean that that was a legitimate dispute. So it's kind of on a case-by-case basis. They have that requirement in there because people make kooky arguments sometimes. And then, of course, the second half of this is you have to be right. You have to be entitled to judgment as a matter of law. So the law has to be on your side if you're making the motion. Okay. A genuine dispute exists if the evidence is such that a reasonable jury could return a verdict for the non-moving party. And that is just a recap of what a genuine dispute means. There has to be some evidence that a reasonable jury could basically rule for the other side. And then we haven't seen this here. This is a citation to a court rule. That's where summary judgment comes from. That's Federal Rule of Civil Procedure 56, subsection A. And then these are fairly famous Supreme Court decisions. I mean, I've seen these all the time. This name, and Anderson versus Liberty Lobby and Celotex, they just set forth the basic premise for summary judgment. So that's just a very common. Okay, the moving party initially bears the burden of demonstrating the absence of a genuine dispute of material fact by citing evidence in the record. And what that means is the person who makes the motion has to basically say at first there's no dispute about the facts. All the facts everyone agrees on. It's just the interpretation of the law. And they have to do that by citing evidence. So basically, they have to put up or shut up. And then if the moving party meets this burden, so basically says that there's no facts in dispute, the burden then shifts to the opposing party, so the person that's defending against the motion, to establish a genuine dispute of material fact. So the person defending against the motion has to say, no, there actually is a dispute about an important fact, and here's why. And they have to, okay, and here we go. In doing so, the non-moving party may not rely on conclusory allegations or substantiated speculation. So this, again, is put up or shut up. This is the time to say exactly why you believe that there's actually a dispute of material fact, and you have to do it with more than just your conclusory allegation. Unsupported allegations do not create a material issue of fact. So this is all just explaining the standard for a summary judgment for the folks that don't understand what that means. A lot of times I might have mentioned this in my first video, but my clients don't understand that you're not entitled to a trial in every circumstance. And so the summary judgment is one of those instances where you're not entitled to a trial. Okay. Section 5, liability and the Howey test. So this is where we get into the actual case law, the Howey case, and also what federal law are we dealing with that is at issue, right? So under Section 5 of the Securities Act, so that's the federal code that we are dealing with. It is unlawful for any person directly or indirectly to offer to sell, offer to buy or purchase or sell a security, whatever that means, unless a registration statement is in effect or has been filed with the SEC as to the offer and sale of such security to the public. So how I'm interpreting that, and just remember, I'm not a securities lawyer, but with my understanding of the law so far, what I understand it to mean is if you have this thing called a security, which we don't know yet exactly what that means, but let's just assume that we have this thing called a security. You can't offer to sell it. You can't offer to buy it. You can't actually buy it, and you can't sell it. So it basically just the security has to stay where it is unless you file a registration statement with the SEC. And a registration statement is just letting the SEC know that it's there and providing some information to the public about this thing called a security so that people can know whether or not it's a good idea to buy or sell it. And then here we have a citation to the statute. So a statute is just a written down code of law. And I can tell this is a federal statute because of some of these signifiers. So we have Title 15, U.S. Code. All right, that's how we know it's a federal statute, U.S. Code. This is a section symbol. And when there's more than one next to each other, that just means more than one. So Title 15, U.S. Code, sections 77E, subsection A, C, and E. So if you wanted to look up this statute, you probably could just Google this part here, 15 U.S.C. section 77E. Not the subsections. You can type in the subsections, but this is all you really need. So you could follow along with us if you wanted to. Okay, so to prove a violation of Section 5, the SEC must show a couple of things, or a few things. One, that no registration statement was filed or in effect as to the transaction. And two, that the defendant directly or indirectly offered to sell or sold the securities. And three, through interstate commerce. So let's unpack this because this is what the whole case is about, right? So to prove a violation of Section 5, so to get in trouble for violating Section 5, the SEC has to show three things. One, that there was no registration statement that was filed or in effect. And I thought we saw in the fact statement that that's not really in dispute. Ripple acknowledges that they did not have a registration statement filed or in effect. So that's going to be off the table. The SEC has already proven that by Ripple's own words. Okay. Number two, that the defendant directly or indirectly offered to sell or sold the securities. Okay. So that's really what I see as the meat of the matter. So how do we look at the rest of the opinion? We're probably going to be looking at this little sentence right here, what comes after the two, this part. That's what we're looking at. And then number three, through interstate commerce. And I can guarantee you that's been proven. Interstate commerce basically means if the security originated in one state, like California, for example, and it gets sold or offered to be sold to any other individual or entity in another state. So like Montana or North Carolina or Florida or something, like that's going to be constituting interstate commerce because it's going interstate. It's crossing state lines. So number three, that's been proven for sure. So let's basically number two is the only thing that we're dealing with right now. Okay. And here, the court goes through it. Defendants do not dispute that they offered to sell and sold XRP through interstate commerce. So judge is saying this number three, that's been proven. They also do not dispute that they did not file a registration statement with the SEC for any offer or sale of XRP. So again, she's saying this section one has been proven. The question before the court is whether the defendants offered to sell or sold XRP as a security. Oh, okay. So this sentence here is actually saying defendants do not dispute that they offered to sell and sold XRP. So even this part right here, that the defendant directly or indirectly offered to sell or sold, that's also been proven. So literally, the only thing this case is about is whether XRP was a security. That's it. That's all that we're dealing with. Okay. Okay. Yeah. Specifically, the SEC alleges that the defendant sold XRP as a, quote, investment contract, which is a type of security as defined by the Securities Act, Title 15, U.S. Code, Section 77B, subsection A1, or A sub 1, So the SEC is saying that it's not just any security, it's a type of security called an investment contract. So now we're going to be finding out what is the definition of an investment contract, and does XRP meet that definition? That's it. That's really as simple as this case should be. Okay, defendants argue that they did not sell XRP, so defendants is Ripple. Ripple argues that it did not sell XRP as an investment contract, and therefore no registration statement was required. So if it's not an investment contract, no registration statement was required, hence no violation of Section 5 of the Securities Act, and this whole lawsuit shouldn't have been filed, and the SEC is going to owe Ripple a lot of money in their attorney's fees. Okay, in SEC versus WJ Howie Co., which is where the Howie test you might have heard about that originated. It originated from a Supreme Court case. The Supreme Court held that under the Securities Act, an investment contract is, quote, a contract, transaction, or scheme whereby a person invests his money in a common enterprise and is led to expect profits solely from the efforts of the promoter or a third party. Now, you see these bracketed numbers. The court is just inserting into there what it considers to be elements or three requirements. And she's going to maybe talk about these things separately. So that's why she added them. So it's just easier to identify what it is she's talking about. So someone has to invest their money in a common enterprise, which common enterprise in layman's terms means, people have to be working together towards a common goal in a business sense, and is led to expect profits solely from the efforts of the promoter. So the promoter is essentially the person who puts the investment together, or like solicits money from investors. It's just the person that is like involved in creating the opportunity that the people are investing in. So the investor has to be led to expect profits solely from the efforts of the promoter or any third party, which is usually the business, right? So, okay. In analyzing whether a contract, transaction, or scheme is an investment contract, form should be disregarded for substance, which is a very common legal uh, phrase, and I'll explain that in a second. And the emphasis should be on economic reality and the quote totality of the circumstances. Now, lawyers, we hear this all of the time, especially going through law school. Uh, Form should be disregarded for substance. That basically means we don't care what you call it. Right? If you have a piece of paper and on the top of the paper it says, this is not a security, and it goes through and it's a stock certificate basically, and it just says this is not a security. Well, we don't care what you write on the paper. If it acts like a duck, if it walks like a duck, if it quacks like a duck, it's a duck. I don't care if you call it a tiger. That's all that really means. So we're going to look at what it actually is as opposed to what it is called. And the emphasis should be on the economic reality and the totality of the circumstances. So we're just going to use all of the facts surrounding what this thing is to determine whether or not it is a security. So that's all that means, is that we don't care if Ripple calls it, if Ripple calls it an XRP token, the court could still find that it's a security. You get what I'm saying? That's what it means. All right. So defendant's essential ingredients test. Now, I will admit to you that I went ahead and I read this, and I'm going to give you a spoiler alert right now. Ripple decided to try and advance a type of a new addition to the Howey test, which it calls the essential ingredients test. And in short, the court denied that. So Ripple tried to add new stuff to the Howey test, and the court said, no, we're not doing that. So you can skip ahead if you want. Let me see. This might actually, if you don't care about this stuff, about something that the court ultimately did not agree to, you can just end this video for yourself. I'm going to create a third video for the analysis, so the meat of this case. But I'm still going to go through this essential ingredients test for one reason, and that is just because the trial court denied this essential ingredients test doesn't mean that it can't be something that can be appealed by Ripple if they wanted to, and take the matter up to the Court of Appeals. And if it gets stricken down there, it might get sent to the Supreme Court. And the Supreme Court would really have the authority to add these essential ingredients test items to the Howey test if it wanted to. But Ripple has to make the argument in order for it to even get to the Supreme Court in the first place. So that's why they're bringing it up. It's kind of like their insurance policy. If they lost the case, they would try to appeal all the way to the Supreme Court. It's a long shot, but hey, we'll see. I haven't actually read the analysis section of the case, so there's been a lot of hype that Ripple actually won this case. So they might not even need to do that. Okay, so let's just get through it. This essential ingredients test that was denied by the judge. In their summary judgment briefing, defendants advance a novel, meaning new, not book, a new essential ingredients test, arguing that in addition to the Howey test, all investment contracts must contain 3 essential ingredients. So in addition to the Howey test, so Howey plus 3 ingredients. A contract between a promoter and an investor that establishes the investor's right as to an investment, which contract 2 imposes post-sale obligations on the promoter to take specific actions for the investor's benefit, and 3 grants the investor a right to share in profits from the promoter's efforts to generate a return on the use of investor funds. So, in order to be a security, it has to meet all of the Howey test factors, which we haven't gone through yet, I think, but oh yeah, we did actually. It has to be these 3 things here, plus a contract, so like some formal obligations between the parties that meets the definition of a contract, plus the contract has to create post-sale obligations so on the promoter. So the promoter has to be bound by contract to do something after the sale for the investor, and it has to be specific actions. So they have to specifically do these things, A, B, C, for the investor. And the contract has to grant the investor a right to share in profits from the promoter's efforts. So the contract itself has to give the investor a right, a contractual right to share in the profits. So those are the three things that Ripple says it should be added to the Howey test. And the court just comes out and says, we're not doing that. The court declines to adopt defendant's essential ingredients test. Why is she saying no? Well, because it would call for the court to read beyond the plain words of Howey and impose additional requirements not mandated by the Supreme Court. The court sees no reason to do so. So she's saying, hey, my boss's boss, the Supreme Court, has, issued Howey, and, I have not been given the reason to overrule the Supreme Court. I mean, I'm just a trial court, so I'm going to do what the Supreme Court tells me to do. Sorry, Ripple. And she says, neither Howey nor its progeny, which means Howey were the cases after Howey that interpret Howey or apply Howey in very famous ways, hold that an investment contract requires so neither Howey nor any of the other cases hold that an investment contract requires the existence of defendant's essential ingredients. So she's saying, listen, whatever it is that you're trying to add to Howey, none of the cases have ever talked about that. So that's just ludicrous. I'm not doing that. So this is actually not good for Ripple. If the crux of their case relied upon this essential ingredients test to Howey, I mean, I hope they didn't hang their hats on that, but we'll see in the next video sort of what happens. Okay, to the contrary, these cases make clear that the relevant test reflects a focus on an investor's expectation of profits from the efforts of others rather than the formal imposition of post-sale obligations on the promoter. So she's saying, listen, the cases that Howey is about, or that, all these cases have to do with the expectation of profits, and that's pretty much it. The expectation of profits from the efforts of others. It doesn't require a contract. Like the definition that Howey puts forth doesn't say anything about a contract, so that doesn't make any sense. That's what the court is saying. Now, the Supreme Court use of the word profits in Howey was intended to refer to income or return, and financial returns on investments are not equivalent to post-sale obligations or profit sharing. So how I'm interpreting that is that just because you're entitled to income or return from the efforts of or profits, basically, doesn't mean that there are post-sale obligations or profit sharing. It's just like it's a broader use of the word profits. It's not as limiting as requiring some sort of contract. Thus, the court is not. And by the way, for those that don't know, contract is a very specific type of legal relationship between two or more parties, or two or more people or entities or whatever, and it requires certain things. And once those requirements are met, a contract creates a binding obligation between those people. You cannot escape from the contract without suffering some sort of legal consequence, like being sued and going to court and getting a judgment against you and then having that judgment collected. So, contracts are very big deals. And once it's created, it's really hard to get out of a contract unless you guys talked about it beforehand on how to get out of a contract. Thus, the court is not persuaded that precedent is like previous cases, basically, supports the consideration of these ingredients in determining whether a contract, transaction, or scheme constitute an investment contract under Howey. So the court's saying, listen, guys, we're just not doing that, okay? And she goes on. You'll see, she just keeps hammering home that she is just not doing what Ripple wants the judge to do. And so again, not good for Ripple, but maybe they have another trick up their sleeve. Defendants do not cite a single case that has applied their test. So, which is not surprising because she acknowledges that it's a novel or new test that Ripple is trying to advance here. So, of course, there wouldn't be a single case applying their tests. They're making it up right now. Rather, defendants contend that the court should look to the pre-1933 state blue sky law cases on which Howey Court relied. And blue sky law cases, that just has to do with like the early days of investments and stuff, like back when the US was more of the kind of like the Wild West. There was a lot of folks that were going around offering these crazy investments and offering, blue sky, essentially. And I might be getting the history wrong on that, but it's essentially blue sky law is our old case law or rules that have to do with investments. So, according to defendants, every pre-1933 blue sky investment contract case involved a contract post-sale obligation on the promoter and the investor's right to receive a profit. So what Ripple is saying here is, listen, all of these cases that Howey relied upon, they all had contracts and post-sale obligations on the promoter and an investor's right to receive a profit. So Ripple's saying, listen, all those three essential ingredients that we talked about, they were all present in these cases that Howey relied upon. So therefore, that really should have been a requirement. It just has been omitted, unfortunately, from the case law since Howey. It's kind of what they're saying, right? So that may be so, but the Howey court relied on the state court's definition of an investment contract as a contract or scheme. So I'm going to highlight that because I think that's important for this. So the court's reasoning here. She doesn't come out and say it, but I think that's important. So the state court's definition of investment contract as a contract or scheme for the placing of capital or laying out of money in a way intended to secure income or profit from its employment when fashioning the relevant test. So, okay. So Ripple is saying that there really needs to be a contract, but take a look at this. The definition of investment contract, at least as the Howey court relied upon, says a contract or something else other than a contract. So you see, already it's basically kind of just destroying Ripple's argument here. Is that if this is the definition we're supposed to be using, it basically contemplates something other than a contract being an investment contract. So the essential ingredients are not really essential, are they? That's how I would view that. So here we go. Had the Supreme Court intended to incorporate these essential ingredients as essential requirements, it would have done so. Sure. In any event, even accepting defendants' survey and analysis of the case law as accurate, so even if Ripple was being completely forthright with their exposition or explanation of these pre-1933 cases, the fact that these pre-1933 investment contract cases shared some common features does not convert those common features into requirements necessary for finding an investment contract under Howey. So, hey, just because these other cases had a lot of similarities does not mean those similarities were requirements. It's the luck of the draw, they were all just similar. Rather, the Supreme Court was guided by the, quote, fundamental purpose undergirding the Securities Act, in which Congress painted with a broad brush in recognition of the virtually limitless scope of human ingenuity. Okay, I hate it when courts talk with flowery language like this, but what is going on here is the Supreme Court is saying that Congress intended for the Securities Act to be broadly interpreted and applied to a lot of different things. So we just didn't want there to be a bright line test where it's like, hey, if you do X, it's a security. If you do Y, it's not a security. Or if you don't do X, it's not a security. Because really, in that situation, there's always going to be someone who can figure out how to get around the rules. So we're not going to have a bright line test. And instead, we're going to give the courts a lot of leeway to determine, hey, is this a security or not? And we're just going to give these sort of like general concepts to help them figure it out on a case by case basis. And I mean, as a citizen, as a lawyer, as just a thinking human being, that's extremely frustrating because I'd like to have some knowledge as to whether or not I'm doing something wrong, which is exactly how we got into this mess with the Ripple case in the first place. So maybe we should have bright line tests. Congress, think about that one. So too must this court be guided. Indeed, in the more than 75 years of securities law jurisprudence after Howey, she keeps going, courts have found the existence of an investment contract even in the absence of defendants' essential ingredients, including in the recent digital asset cases in the district. So, hey, there's been 75 years since Howey, and we've even found investment contracts without the contracts that Ripple is saying that there needs to be. So she gives these two examples from her own court, the Southern District of New York. That's what SDNY means. There's SEC versus Kick Interactive Inc. and also Balestra versus ATB Coin LLC. And she quotes from that case, ATB coins do not entitle purchasers to a pro rata share of the profits derived from any ATB managed transaction. However, such a formalized profit sharing mechanism is not required. So this really is suggesting to me a contract, a formalized profit sharing mechanism. And she's saying specifically in that case, the ATB coin case, they said a contract is not required. So in order for Ripple to succeed in this essential ingredients test, the court would have to say that Balestra was wrong, that case was wrongly decided, and she's just not willing to go that far. She says, and this makes sense, given that the Howey test was intended to embody a flexible rather than a static principle, one that is capable of adaptation to meet the countless and variable schemes devised by those who seek the use of money of others on the promise of profit. So again, that's just more flowery language saying that, hey, this test is not supposed to be very rigid. It's supposed to be very flexible. Put differently, the Howey test was intended to effectuate the statutory policy of affording broad protection to investors, protection that is not to be thwarted by unrealistic and irrelevant formulae. So again, saying, I read this to mean there's going to be con artists out there that are going to figure out ways to outsmart investors, even if we have a bright line test. So it's not supposed to be bright line. It's supposed to be broad and murky on purpose. I hate that, but that's just what the court is saying. So accordingly, the court rejects defendant's argument that all investment contracts must include post-sale obligations on the promoter and grant the investor a right to share in profits from the promoter's efforts. So she's saying, we're not going to do what you want us to do in this situation, Ripple. So, okay, the court does not reach defendant's first essential ingredient, that a contract must exist for an investment contract to exist. So what she's saying here is, listen, because I'm just throwing your test out altogether, I'm not even going to start talking about each ingredient specifically. So the whole test is out. So I'm not going to waste my time talking about each ingredient. And there's a footnote 11. The SEC's opposition papers misconstrue defendant's essential ingredients test. The SEC dedicates several pages to refuting the argument that a written contract must exist, but the defendant's proposed test does not turn on the need for a written contract as opposed to an oral or an implied contract. So okay, what that means is you can have a contract that is not in writing. I mean, I think most people have heard of a verbal agreement. So just because a contract does not have a piece of paper, does not mean that it's not a contract that you can enforce in a courtroom and all that stuff. So she's saying the SEC just didn't understand that. Like the lawyers that worked there were not smart enough to figure out that Ripple was only talking about a contract and not necessarily a written contract. So she just says, I'm not going to address the SEC's argument that Howey does not require the existence of a written contract because that's not even what we're talking about. We're not talking about just a written contract. The SEC didn't even understand what Ripple was saying, is what she's saying with this footnote. And that's really funny because she's really slapping at their intelligence there. Okay, as discussed in greater detail below, in each instance where defendants offered or sold XRP as an investment contract, a contract existed. So she's going to get into that in the next section here, which is the analysis. So we've made it to page 14 out of 34. So I'm going to end this video here, and I'm going to make a new video going through the analysis, which is really the meat of the case. So stay tuned. Thank you very much, and I'll see you next time. Thanks.